The people of the state of Michigan versus Danana May, file number 23-02204, council appearance.
This is the prosecutor, Paige Petrosky, on behalf of the people.
Thank you, Your Honor. Tiffany DeBurn on behalf of Danana May, who's currently seated to my right at council table.
And this is day 2 of the continuation of the jury trial. The jury is present. We're ready to call them in. Any matters that we should address before we do that?
No, Your Honor, not from the defense.
And nothing from
The jury. Okay, you can be seated. Thank you all for being so timely today, including or notwithstanding the current weather we have. Everyone's notepads was where they left them, correct? Okay, very good. We were on defense witnesses. You can call your next witness.
Thank you, Your Honor. I would call Danana May.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
If you can have a seat. Okay, Ms. May, you understand that you have the right to remain silent?
Yes.
You understand that that's an absolute right under the Constitution, and that by testifying, you would give up that right? Do you understand that?
Yes, I do.
And you also would allow or open up the opportunity for the prosecutor to be able to cross-examine you?
Yes, I do.
Okay. Is anybody threatening you to get you to give up that right and testify?
No, Your Honor.
Has there been any promises made to induce you to give up your right to silence to testify today?
No, Your Honor.
Okay. You can further voir dire or question your client.
Thank you. So go ahead and state and spell your name for the record.
Danana May, D-U-O-N-N-A, last name May, M-A-Y.
Okay. You're here because you want to tell your story.
Yes.
Okay. So, and what I'll say is if you don't remember something, just tell me something. I don't want you to make anything up. Just tell me. Or ask. So let's talk about your relationship with Stephen. How did you meet him?
I was sitting on my front porch at my townhouse.
So explain, like, that's not.
I was sitting on my front porch at my townhouse waiting for my oldest boy, Josh, to come home. He'd been out cutting grass with my friend Dave.
How old is Josh?
15.
Okay, and do you have another son?
I do.
How old is he?
Marcus, he's 10.
Okay, go ahead.
I thought that the car that had pulled up was my friend Dave. We had similar cars and just been sitting there. So I went and tapped on the window and I said, "Hey, did you guys just gonna sit in the car all day?" He rolled down the window and that was not Dave. I said, "Oh, I'm sorry." And no, and come talk to me. And I was like, "No, I'm good. I'm just waiting for my son." And then he asked for my phone number. I turned it down a couple times, but he'd come to the neighborhood after that, and I eventually said yes. He did end up going out.
What happened? So I guess tell us more about how the relationship kind of worked its way out.
Well, it started out good. I mean, dinner, flowers, movies, typical dating.
Okay.
Then he would, after a while, he would buy shoes. He would start going to better restaurants, like UK.
So like you started out a little rough. I mean, was this like Wendy's and stuff? And
No,
then
I
you
mean,
stepped
it
up to
was,
dinner?
I mean, it was just Applebee's was actually our first date.
Okay. Okay.
So,
I've had worse.
yeah, I mean, it wasn't bad. I mean, Applebee's was a fair start.
Okay. So it got better though.
But it did, it got better, and he was really nice, and he kept coming around more, we were calling more, talking more. I have a full-time job, so it makes it a little difficult with everybody else's schedule. It's kind of always, you know, but, made time, and that was important.
Okay. So did there come a time when you guys moved to the next step in the relationship?
We did, after, I'd say about 5 months or so, I introduced him to my kids.
Okay.
He had come over with a pot of chicken noodle soup.
So let's talk about, because I don't know that we started, when did you meet him? Like, do you remember even a
I
time
want to
frame?
believe it was around August of 21.
Okay, okay. So he came over with a pot of chicken soup.
Yes, and that was when he met my kids for the first time, and I wasn't in the house.
Okay, so if that was August, we would have been popping. I can't do math. That's August is 8, so January? February of 22? August, September, October, November, December, January.
It would have been August of 21.
So if you met August of 21, then you introduced him to your kids 5 months later, January 22.
It's about 5, 6 months later.
Okay. So we got a time. I'm very I'm chronological. I like a time frame. Go ahead. So what happened when he brought the chicken soup over?
We ate dinner.
Okay.
It went well. He didn't stay long. He went home, and that was that for that night.
So how did things go after that?
The kids liked him. They seemed to be okay with him. And so, single mom, I need help. I mean, he was always helpful. He helped take the kid, my youngest son, to school. I would pick him up after school. I guess the relationship did move kind of fast.
I don't know. I moved in with my husband 5 to 6 months after we met. So it is what it is. So did you get to the point where you guys took it to the next level?
Yes.
Tell us about that.
I was allowing him to stay the night.
Okay.
And like I said, I was allowing him to help me with my children, taking my youngest son to school. And we were having more dinners together. At some point in time, he had suggested that we move in together, which had saved money.
Okay.
Which sounded great. Split those, having help with the kids.
You remember when? Well, so you ended up moving together.
We did.
Okay. Do you remember about when that was?
Well, my stuff had gotten moved slightly beforehand. I had started moving it, I want to say around November, maybe December, but I was officially moved out. My apartment was signed off as first of the year.
Okay, January 1st.
Yes.
So you ended your lease, moved in with them.
Yes.
Okay. Did there come a point where things started to get a little rough?
Shortly after I moved in.
Okay.
After I officially signed off my apartment.
Tell us about that.
I wasn't able to cook dinner fast enough. I wasn't cleaning enough.
What do you mean?
Josh wasn't helping enough.
Was he saying these things to you, or what do you mean you weren't?
It was, I would no more than walk in the door from work and he would ask if dinner was done. I hadn't even set my keys down yet.
Okay. What else?
Shortly after that, it was just, I just couldn't do anything right. I just couldn't do anything right. I don't even know how to elaborate that. He would ask, how come the laundry wasn't folded? I had just gotten home. I hadn't even pulled it out of the dryer yet. I hadn't started it quite yet. I just walked in the door.
Did you talk about you deserving things?
He had talked about it a few points where I didn't deserve to have lunch.
What do you
Or,
mean? I don't understand.
I would pack both our lunches, or sometimes I would pack his and I would eat enough for mine because he would want more, and he would tell me that sometimes I didn't deserve to eat. When wintertime came around, because he used to brush off my car for me for the longest time, every morning he would come out and straighten my windows and brush my car off, and then after time, it just became, I wasn't deserving, I didn't deserve to have my car brushed off. He would come help me, but I didn't deserve it.
Okay. Did there come a time when it got really bad?
I don't remember what happened. He struck me once in February.
February of what?
I believe it was,
We're in 24 now. You said that you moved in January of 22.
22. It would have been February of 22. And I remember it because it was just shortly before Valentine's Day. I ended up leaving and going to my friend Dave's house.
Okay, so slow down. You said he struck you?
He backhanded me.
Okay. Do you remember the details of what happened?
I don't.
Okay. Well, then how do you know that, you know what I mean? So when you throw something out like this and say, well, I don't really remember what happened, like what are we supposed to think? So why should we believe that happened? Do you understand what I'm asking?
I do.
Okay. So what's your answer to that? Did you have a mark?
I had a small bruise on my face.
Did you take a picture?
I did.
Where's the picture?
I don't have.
Okay. What happened to it?
I deleted it.
Why?
It's embarrassing.
Okay. Did you think that you were going to have to use it in a court case 2 years later?
No.
Why'd you take the picture in the first place?
Because there was no mirror inside the bathroom. In Dave's house.
Okay, and so you wanted to see what your face looked like?
I did.
Really? There's a guy that doesn't have mirrors in his house?
He is 68.
I don't know. I want to see myself. Okay. Okay, so, all right, so after the February incident, did anything else happen? How did the relationship go? Well, let me back up. I'm asking you a lot of questions. Did you have an interaction with Steven about this, about the incident? So you were at Dave's house. Why did you go to Dave's house?
I went to Dave's house because I didn't want it to escalate anymore than we already had.
Okay,
All I did was leave, and I didn't talk to him for a couple days, and then we did talk. He called.
did he change the locks?
He did change the lock.
Okay,
He ended up giving me a key back.
did he apologize?
He apologized. He said he was sorry and didn't want to do it again, and that he wanted to fix the relationship.
Okay,
And I agreed.
okay.
I said yes.
Moved back in.
And
So how did the relationship go after February?
it went really well, actually. It was right back to everything being just the way it was before.
Okay,
It was back to dinners and us talking and yeah, just normal, I guess would be the best way to explain it.
okay.
And
Did you call the cops after this?
I did not.
Why?
I just didn't believe that. I don't believe that cops fix anything.
So did anything else happen of substance after the February incident?
No, not for a little while. I mean, it actually went so well, he proposed to me in April. On my
Okay.
birthday,
On your birthday? When is your birthday?
April 14th.
Okay. So he proposed on April 14th of 2022?
Yeah,
Okay. That's a pretty big deal.
it was a big deal.
Are you excited?
I was very excited. Went out to dinner.
Okay. Yeah, that's some good stuff. So then how do things go after the proposal?
Not too bad. They went well for a while until December.
Okay. What happened in, so you're saying the next thing that happened was in December, 6 months later?
Approximately,
Wait a minute, April, no, that's
or
8 months later.
whatever April to December is.
Okay.
Yeah.
So tell us about what happened in December.
We'd gotten into an argument. Oh. August was our next. We were good from April until August, when I came back from Kinross, when I came to see I went to go see my brother, I came back from seeing my brother.
This is August of 2022.
That would be August of 2022.
Okay, what happened then?
I was tired. I was very tired.
Okay.
It's a long drive. I had driven back. And I dropped some of the stuff off at the house. I still had to take my mom home, and I still had to get shoes for the kids. It wasn't very, I guess, yeah, I was just tired. And we got into an argument because I wasn't excited to see him. Not as excited as I should have been.
Okay, and so what was he doing?
He was just yelling at me. I couldn't tell you what for.
Okay,
Just that he wasn't happy that I wasn't as excited as I should have been.
what was your response?
I fell asleep during the argument. While he was yelling at me, I fell asleep.
And then what
And
happened?
I woke up to him ripping the ring off my finger.
Okay. So he was, you mean the engagement ring?
The engagement ring, yes.
What happened after that?
I went to try to leave, and he blocked the door. We were upstairs in the bedroom.
Okay,
And when I tried to move him out of the way, he grabbed me by the throat and choked me. I don't remember how I opened the door, but I managed to open the door. I grabbed my kids and we left.
so he just let you out, or?
No, he had his back against the door.
Okay,
I was pulling on the knob and trying to push him out of the way.
so this happened a year and a half ago. How do you remember?
Because I've taken a great trip to my brother's house. It was a very good weekend at Mark until I got home.
Okay, so you're saying he choked you, like choked you, are we talking one hand around the neck, two
Two
hands?
hands, his
Okay.
back against the door.
Okay. You were somehow able to get out of it.
I just kept pulling on the door and trying to use my elbow to push him away.
Okay. And you got the kids and you left.
I did.
Did you call the police?
He did not.
So he choked you, like choked you, and you did not call the police.
No.
You understand how that's happening? Okay, so you said you left. Where'd you go? Okay. Dave didn't call the police.
He did not call the police. He doesn't lock his doors for me.
What do you mean?
So I think he goes there, please.
Well, I know, but even like a good friend, you would think that they would see what's happening. They didn't call the police.
No. If I
Did you have
say
any
don't call the police, I had minor marks.
Okay. When somebody chokes you, you know what I mean? Usually there's a mark. Did you take pictures?
I did not. Not something I'm gonna show everybody. I'm not gonna show anybody.
So what happened then? What happened with your relationship with Steven?
Ended up going back.
Why did you?
I'm sorry. Where am I gonna go with two kids?
He choked you. Choked you.
Mhm.
Thanks a lot.
He did change locks. He had a whole bucket of locks by the end of this entire thing that was over dedicated to me.
You mean dedicated to you, meaning he changed the locks?
He had
Those were all
changed
the locks he had changed.
multiple times, yes.
And he just kept them all on a clock. it?
He did.
Did he tell you? Oh, here are all the locks that I've changed.
No, cleaning the house one day, I saw it.
Do you ask him about it?
No,
So you're just assuming that these are all the locks he's changed. He didn't.
you kind of just know when you see lots of locks in the trash.
Okay, all right. So after the August incident, you went back.
I did.
Okay. So how did things go after that?
They were okay. I mean, it was still like walking on eggshells around the house. But that's it was, everything was just different. It's just, I wouldn't help him with detailed cars. Out of my shift, I go home, I cook, I clean, I take care of the kids, do homework.
So this is what we've talked about 3 or 4 incidents now. Why did you stay? I understand where do you go with 2 kids, but why?
I was working on it. I eventually did end up slowly moving my things out. My surgery in April slowed me down.
Okay, well, let's talk about, because the last thing we talked about was August, right?
Yeah.
So after August, did anything else happen between that time and this incident in June of next year?
Right before Christmas. We'd gotten into it
Okay,
and
so that was December of 2022.
yes,
Okay,
December of 2022, we'd gotten into it shortly before Christmas. And he had hit me. I asked my friend to bring me makeup at work.
oh, and is that Irene that testified yesterday?
Yes,
Okay, so when you say December, he hit you, do you remember details of what happened?
I don't.
Was it just getting so common?
It was getting pretty common.
Okay, so he hit you. Let me ask you, during any of these times that we've talked about so far, did you hit him and just wail on him?
No,
Because you heard him say in the body cam that he had to defend himself. He had to kick at you just to get you off him.
Steven has never kicked me
Okay,
and
But-
I've never came at him.
in your how tall?
5 foot.
And I know women never want to divulge this, but how much do you weigh?
About 160,
Okay, and he's what, 5'6", 5'7"?
5'8", 5'10", maybe.
Okay, and he has a pretty slight frame, right? He's not a big dude. Right?
No, he's fairly small.
Yeah, so, but so I just want to make sure we're all on the same page. Was there any point that you hit him during any of these incidents you're talking about?
No,
Because you heard him say that you just wailed on him 5 or 6 times, and then he had to kick you to get him off.
no,
Okay, okay, I just want to make sure. So December, you said you don't really remember what happened.
no. It happened in the middle of the night. I dragged my kids out of bed. I was in the dining room and my kids were standing in the living room doorway and getting ready to leave.
Okay, where did you go?
Dave's house,
Okay, how long did you stay?
maybe 2 days.
Okay. We know you remember that.
I did go back.
Did you call the cops at all?
No.
Okay. Did you have any injuries from this one? Did you have any marks?
I had minor bruising and swelling on my face.
Okay. No photos.
Yes, that was the last photo I had.
What do you mean the last photo?
I needed makeup. And so I took a photo and sent it to my friend to ensure that I had makeup.
Okay. Is that the one she talked about yesterday? You have that photo?
I do.
How do you have that photo? Did you keep that photo?
I did.
Why?
I don't know.
Approach. I'm handing you what's been marked as defendant's exhibit A. Can you take a look at that? You recognize for you? No, just you. Just you look at it. You recognize it?
I do.
What is it?
There's My eye fairly swollen in my face.
Did you take this picture?
I did.
When did you take it?
It worked around 6 something in the morning.
Okay, and what was your purpose in taking it?
She asked if I had put on enough makeup.
And who did you ask that to?
I mean,
Is this an accurate reflection of your face as it was when you took the picture?
No.
Okay, it's not an accurate
Yeah.
reflection?
oh, yes.
That's okay. I understand. So it is an accurate reflection of your face as it appeared when you took the picture.
Yes.
Your Honor, I move for admission for defendants exhibit A.
Any objection?
No objection, Your Honor.
Defendant A is admitted.
Thank you, Your Honor. Permission to publish?
Yes.
All right, so after December, did anything else happen?
The next event that had happened was in April.
Okay, let me take you back for a second, because there's a little bit of a red mark in this picture. Is that what you're saying the mark was?
Yeah.
Okay, sorry, just to clarify. So. You said something happened in April.
Now we're into 2023.
Okay, what happened in April?
Well,
Well, yeah, actually, let me ask you, so you took this picture and you kept this picture. So at this point, it seems like you're getting to the point where you're done.
yes.
Okay, so you keep the picture. What else are you doing?
Slowly moving my stuff out.
Okay. Why is it slow? Why is it slow?
I always use the same.
Okay. It's a fair answer. So what happens in April?
Well, it was my birthday.
Okay.
April 14th, so on Friday. I went to work. Didn't celebrate it. I think you might have forgot.
Yeah, well, he didn't know it yesterday.
And so Saturday, the following day, I went to work. And I waited thinking we were gonna go out. We didn't, and instead we got into an argument. And he took the ring off my finger and left.
So I gotta say, like, it's gonna be hard to rip this thing off my finger. Like, I can't. Okay, I can barely get it off right now. But you talked about him ripping the ring off the finger. So you gotta understand how that sounds like.
My weight fluctuates quite a bit.
Preach. Okay. Go ahead.
But yeah, it comes off my finger somewhat fairly easy.
Okay.
So he had taken it off my finger, and so yes, I had got upset. I probably left. I left shortly after he did.
So that's all. You ripped the ring off your finger. It didn't hit you, didn't.
No,
Okay.
there was nothing. He ripped the ring off my finger, and he had left.
Okay.
There was no altercations, just him and I arguing because I didn't want to help him detail cars on my book.
Okay. So better than the other ones. What happened after that? Because we know, I mean, did anything happen between that and the June incident we're here for today?
Yeah.
Okay. But you stayed there, right?
What's that?
You stayed there, right?
I did.
Okay. Where's the ring?
I don't know.
Okay.
He took it and then he left. Being as it was still my birthday, I left too.
Okay. So let's fast forward to June 22nd.
Okay.
Do you remember that day?
I do.
Okay. It's pretty big. So that makes sense. Tell us about what happened.
Well, I'd gone to work. I worked my regular shift.
What do you do?
I'm a housekeeper
Okay.
for a factory.
Okay.
After work, I stopped by Walmart. Prior to this, I purchased some starter tomato plants. And from Horrocks, I stopped over to Walmart in the gardening section. I picked up a couple bags of potting soil. I was probably there for a little while because I don't know a whole lot about gardening. It's been quite a while. I picked up my soil and my phone had rang, but I didn't answer it. I was driving. And so I get home and I'm excited. I was talking to Zach on the porch.
And
I got
Zach is who?
Zach is his friend and roommate.
Was he the one that was sitting at the table in the video?
No, that's Mike, his other roommate.
Okay, so you're talking to Zach on the porch. Go ahead.
Well, I was excited for two reasons. I had gotten a late birthday gift from a friend, and I'd gotten a Hocus Pocus notebook. And I had my bags of soil, and I asked Zach if he was still going to help me plant the tomatoes. He said yes, that he would still help me plant them. And we're out on the front porch talking for a few minutes, and then Steven had come through. And I don't remember the first thing he said, but the next thing he said was, "Where the hell was I?" Before I knew it, he was just kind of trailing me through the house, asked me where the hell I was, what I was doing, was I out effing around, and just really getting under my skin.
Was he calling names or was it just pleasantries?
Stupid bitch.
Now, when he's saying this stuff, is he using his normal tone of like, because you're saying stupid bitch?
No, it's not a normal tone of voice. It's, where the hell were you, stupid bitch? You were out fucking around, weren't you?
So like, is he saying that or is he yelling?
It's a louder, antagonizing, trying to start a fight, just in your ear.
How loud are we talking? Like, see, I have an outside voice, so I'm like, where the hell you at, you stupid bitch? You know what I mean? Is that what we're talking, or are we talking?
Probably a little bit lower than that, but
Okay.
pretty close.
Okay. And now, how far away from you is he?
I mean, no more than just a couple feet.
Okay. And when you say he's trailing you around the house, what do you mean? Like, what are you doing? Are you just?
I was well, as I'm coming in the house, I'd set a couple things down because I'd already set the potting soil on the porch. And then I didn't make it very far in the house. I come around to the doorway area. And I don't know, I guess at that moment, I just decided I was done. I looked at my son, Josh, because I hadn't even set my car keys down yet. I hadn't even been there that long. And I said, "Josh, pack your video games and we're leaving."
So Josh is in the living room area?
Josh
Okay,
is in the
so
living room.
when we see the camera, like do you guys remember the camera shot that we saw? So from the camera, it's like you're looking down the hallway, I guess.
You'd be looking from the living room into the dining room.
Yeah, and we saw a couch on the left and a chair on the right, and the archway.
Yes.
And then there was a door and a kitchen table, right? So where was Josh? Where was he?
Josh was in the living room. He would have been, well, as soon as Josh heard the arguing going on, he kind of came out into
Okay.
the archway, and
Makes sense.
I was standing between the archway and the table. I looked at Josh. I handed him my car keys. I said, "Get your video games and stuff and go start the car."
Okay,
So he grabbed his video gaming stuff and went out and started the car.
okay.
I went upstairs. I grabbed Marcus, or well, I didn't grab Marcus. I went upstairs. I told Marcus to grab his video games and stuff that we were leaving.
Okay, so let's talk about upstairs, because we saw kind of, the information about the lower floor, but tell us about upstairs. What's upstairs?
Upstairs, there are 2 bedrooms and a table in the hallway. It's a fairly narrow hallway.
Okay, so when you get up at the top of the stairs, what's where?
When you get up to the top of the stairs, immediately to your left is a small mini rail, just so you don't fall over the stairs. And right there, very next to the rail is my son's room.
Okay. So you tell him, get your stuff, let's go.
Yeah.
Then what next?
Then I go to the bedroom, and
So the bedroom, is that your bedroom
that
with
would be our
Steven?
bedroom.
Okay.
At the end of the hallway,
Okay,
past a small table that was up there.
okay.
My bags had already still been prior packed from having my stuff thrown out on the porch for my birthday.
Bags were packed for 2 months, because we're talking April 14th to June 22nd.
Yeah,
Okay, your bags were still packed.
I never unpacked them.
Okay. So go ahead.
I grabbed a couple of bags from upstairs, and Marcus had already went downstairs. I watched him go downstairs. I'd gone to the bedroom to grab a couple of bags. And when I went to go down the stairs, I had to pass him,
Who?
Steven.
Okay,
He had pulled my ponytail and shoved my head into the wall. Really hard.
okay, so I'm not sure I understand what you mean.
He grabbed my ponytail and ripped my head. He ripped the ponytail to cause my head to hit the wall.
Okay. I'm a really visual person. Judge, at this point, I would request permission to allow her to leave the stands to help me demonstrate what happened. Thank you. Okay, so those are small walls. I'm gonna come over to this wall over here where the fan is and have you come down with me, okay? So let's play this out. Where are you trying to get from here?
You want me to go down the stairs.
Okay.
So the wall is gonna be for here.
Okay,
The stairs are going to be here.
okay. Can everybody see what she's doing?
Stairs are here,
Okay,
rail is here, wall is here.
okay. So where's Steven?
Steven, bedroom is back here. Steven is right here by the table.
Okay, so I'm gonna have, okay, so I know there's a height discrepancy here. Bear with me. All right, so I'll give you a couple inches, but let's just pretend that my hair is in a ponytail, okay? So I've got, now, how did you have your bags?
I had my one bag over my shoulder, the
Okay.
other one in my hand.
Okay, so what happens? Yeah, I've got my stuff, I'm
You get ready
going.
to go down the stairs.
Yes,
Get ready to
yes,
go down the stairs. And then a small kick to the back of the leg.
okay, so, but you, like, I kind of hurt a little bit.
Sorry.
No, I don't. It is what it
The only
is.
way I can-
I'll do it.
I can only do it.
And you only hit my head once on this thing. So you grab the ponytail and can you do it one more time? I'm sorry, I know this is not fun. Okay, and then what did you do? Can everybody see my knees? Do that one more time.
It was just a graze, just enough to buckle me.
Okay. Okay. Do you feel like that accurately reflects what happened?
Yes.
Okay, go ahead back to the stand. Now that doesn't. Well, I also think this might be cement. Like, I think this may be one of the, yeah, so that's not stellar, but, okay, so he does that to you twice. Then what happens?
I don't really remember much after that, to
Okay,
be honest with you. Had it not have been for the video, I wouldn't have remembered grabbing my laptop.
okay. So somehow you get downstairs, right? You saw that in the video, you grab your laptop. And then what happened?
I'm going to the car and leaving.
Okay. I know you said you don't really remember what happened. Do you remember if anything was going through your head at that point?
I was just trying to leave. I'm trying to get to my kids. I know they're in the car.
Okay. Were you afraid?
Yeah, I still am. I switched cars since then. I bought locking gas caps.
Why?
I later on found out that he was putting sugar in my tank. I forgot back in June, I went to pick up my Jeep from his shop and he had pulled the ignition out. He'd I don't know how he managed to pull the window down on it. He had pulled the window down to unlock the car. He'd taken the front end off my Jeep. That was the first thing I saw.
Back in July, you said?
No, this would have been June.
June of 2023. Well, this happened on June 22nd. So you're saying between the 22nd, you left for 3 days. You know what I mean? You were at your friend's house for 3 days.
Mhm.
So you're saying in the 5 days that remained in June, I don't know how many.
I didn't pick my Jeep up until the 27th.
Okay, so your Jeep was somewhere else.
It was at his shop, yes.
Okay. And he does car stuff for a living?
Yes.
Okay.
I've also put up cameras around my property.
Okay. When you say your property, do you mean the house that you live at with your mom?
Yes.
Did you do anything else to protect yourself after this?
I filed PPO.
Is that PPO granted?
Yeah.
How long will that remain in effect?
I believe until the 29th of June this year.
2024?
24, yes,
And he actually filed a motion to terminate that PTO, didn't he?
he did,
That was denied, right?
yes,
After a hearing, right?
2 hearings.
2 hearings, okay. And I want to ask you something real quick, because you heard him say, she gets nasty when she gets drunk. Were you drinking this day
No,
on June 22nd?
no,
Had you had anything to drink?
no.
So what do you remember next? What's the next thing that pops into your head?
I remember leaving. I remember slightly talking to my girlfriend on the phone. I really don't even remember how I made it to her house.
So, and I want to make sure you saw the video.
I
Right?
did.
And you are calm and cool and collected today, right?
Yeah.
In that video, get out of the way, motherfucker. You remember that?
I do.
You remember saying that?
No,
That's you, right?
it
It's
is.
a very different picture today, right?
Yes.
So you go over to Irene's, right?
Yeah.
Okay, and then what?
Stayed there for a few days.
Did you call the police?
No,
Why not?
I still scared.
Just testified a few minutes ago that you were done.
I was done, but that doesn't mean I have to destroy someone else's life.
Were you concerned that you had any injuries?
Yes.
Okay. What were you concerned about?
After I had a headache and I don't recall. I lost a couple days. I don't remember the days.
And you didn't go to the hospital?
I did not.
You know what I mean? Irene was worried about you. She testified yesterday that she tried to get you to go to the cops.
She did. Several times.
Okay. And you were concerned, what if something happens to you? Then what happens to the kids? You know what I mean?
Yes.
These are all things that people want to know about. Why didn't you do any of this?
I'm so scared. Most of the time I feel like I'm able to handle anything. I'm good at walking away.
But you didn't. That's the thing. You didn't in this case. Time and time again, you did not walk away. Do you mean you're good at walking away and just brushing it under the rug?
Yes.
Okay. No, that's different. Okay, so he testified that there were, I'm gonna change topics. So hopefully I'm not gonna make you cry. He testified yesterday that there were, I think, 6 to 8 cameras in the house. To your knowledge, how many cameras are there?
There are, okay, there's one on the front porch, right above the door entryway,
Which way is it facing?
towards the road.
Okay.
The other one is facing towards the door.
Okay, so wait a minute, there's 2 in that same location?
Yes,
One is facing the door and one is facing the entryway?
yes,
The same way you came out that night?
yes,
And that was there when you left?
yes. It was there when I moved in.
Okay, where else is, so that's 2 cameras, where else?
There's one in the living room, I believe 2 in the dining room.
Okay,
one-
so hold on, one in the living room, is that the one we saw the picture of the 17-second clip from?
Yes,
Okay, so there's a second one.
I believe there's 2 in the dining room
Okay, in the dining room, so when you say dining room, is that where the table is?
where the table is.
Okay, and where are those faces?
Those are facing towards the wall, which there's a bedroom right there.
Okay,
Across from the table.
okay. They're both facing at that wall?
Yes.
Okay. Yeah, it just doesn't make a lot of sense to have two facing that way.
I don't know why there's two in bang on anyway.
Okay, go ahead.
There's one in the kitchen,
Where is that one facing?
towards the stove sink area,
So kind of
right next
not,
to the bathroom, behind the bathroom door.
okay,
There's one in the basement. There's one outside above the back door. There's one on his shed,
okay.
and that's all that I can remember. And there's one upstairs in the hallway.
So there's one upstairs in the hallway where he slammed your head against the wall 2 times.
Yeah.
And that one was there when this happened?
Yeah.
How do you know that one was there when this happened?
I helped him install that one and the one in the living room. Helped him set it up.
That is fascinating. Okay. So I didn't keep count. What, are we talking like 10? You said 2 outside on the front door, 1 in the living room, 2 in the dining room, 1 in the kitchen, 1 upstairs, 1 in the basement, 1 on his shed, and 1 on the back. So that's at least 10, correct? Okay, so at least 10 cameras. Do you know what kind of cameras they are?
I know the one above the door facing the road, the one in the living room, the one upstairs, the one in the basement, the one on the back porch, and the one on the shed are all of the same brand. It's Nui or
Norio?
Norio.
And was that you saw the little, I don't know what it's, the emblem or something up on the left-hand side of that, the video, right?
Yeah,
Norio. And what do you know about those cameras?
I know that they're a lot better than mine.
Okay,
They're 8 gigabytes. I know that they're battery operated, that you can pause, rewind, stop, and they hold quite a bit of memory.
can you send like 17-second clips out of a whole 24-hour time period?
You can.
Okay. And so you heard him yesterday say that, well, do you know how long of a footage period they can hold?
I know that they can hold for months. I mean, weeks. I mean, even with mine, I have cheap ones, and I could show you. I can rewind for up to 30 days.
Okay. And you heard him say yesterday that your phone can be a modem for these things?
Yes.
Okay. So what would we have seen or heard if we saw more?
If you have seen or heard more of that video footage prior to that, you would have heard me yelling, "Stop, let me go,"
And when was that?
before I came down the stairs.
So would we have seen the video of him slamming your head into the wall twice?
You would, and you would have even heard the video downstairs before you saw me come around that corner. You would have heard me yelling.
Okay. Okay.
Those cameras pick up great sound.
Yeah, it's like there's pretty good detail in those cameras. I don't have cameras. I just assume because I don't have cameras that a lot of other people don't have cameras. But apparently it's more common than I think. And I certainly don't have cameras in my house. Okay, brass tacks time. Did you, well, actually, before I do that, do you know how long, I know you said you don't really remember. Do you know how long it was from the time that he slammed your head into the wall and you got outside?
I couldn't be precise. A moment.
Okay. So he's literally trying to get us to believe that this video snapped back on right as you were coming around the corner.
Yeah.
To leave.
Yeah.
Which he didn't want you to do. Okay. Did you punch him anywhere in his face?
No.
Did you hit him anywhere in his face?
No.
Did you intentionally shove him into the courtroom, the courtroom?
I don't even see how it's possible, but he hit the coat rack that's behind the door.
What do you mean when you say that?
The coat rack is literally 2 silver bars behind the door. One is about my waist level, and the other one is far above my head. He's not much taller than me, it's above his head,
And it's attached to
to the wall.
so, okay, make sure I understand. If we've got two walls, you're saying one goes in here and the other side goes in this one?
Yes, they're
And that's-
2 long
okay.
metal poles that are attached to the wall. One's very high up and the other one is about my waist level.
Okay, so let me
behind
just
the
make
door.
sure I understand. And there's gotta be room for you to get in once you get in the door, right?
Yes,
So let's just say we're opening this door. Let's just say this is the door. And the door opens like this. You're saying the coat rack is
behind
behind
the door,
this?
yes.
Okay, but I mean, so there's gotta be, once you get the door open, there's gotta be some space, like maybe between me and the pews, right? I don't know, benches, whatever, they're called, right?
There's, it's just a small area, but yeah, the coat rack is behind the door that you go out.
Okay. So he could have fallen into the coat rack. He could have, because there's that space where the coat rack goes between both walls.
There's also a small table, but the table is also very small.
Okay. So I guess let me ask you
Either way,
again,
he's not falling into the coat rack.
were you just trying to push him to harm him, to injure him, to offend him?
No, I'm just trying to leave. I'm trying to get outside to my kids.
Who else was at the house when all this happened?
Zachary Thornburg, Michael Delmarter. And before my children went outside, my 2 children, Joshua Campbell and Marcus May.
Okay. Your mom said that CPS was called a couple times, right?
Yes, yes, they were.
And what is the status of those investigations, to your knowledge?
They were open and closed.
Okay, do you still have your kids?
I do.
Have you learned your lesson?
There's more than one in my lesson.
No further questions.
Cross-examination.
Thank you, Your Honor. Sorry. Write my notes fast and then I can't read them later, so just bear with me, but. So I want to talk specifically about your testimony about what happened on June 22nd, okay? On June 22nd, once you guys are downstairs, it's safe to say that you were upset, right?
Yes.
Were you angry?
I wouldn't say I was angry, but yes, I was upset.
And how are those two different for you?
Because I was still fairly calm.
You heard the video. Is that you fairly calm?
No,
That's,
it was in my way. I need to get to my kids. I just wanted out the door.
if someone's in your way, do you think that it's okay to put your hands on them to move them?
No,
Even if you're angry at them?
no,
Even if you're upset at them?
no,
If a stranger did that to you because you were in their way, would that be okay?
no.
But we saw you do that on the video. So is that okay? You wanted to get outside.
Okay.
Did you push him because you thought that would get you outside?
Yes, I was trying to move past him to get outside.
Move past him and push him are different. Did you push him because you were trying to get outside?
Yes,
Did he want you to push him?
Objection, Your Honor. Well, you know what? I will withdraw my objection. You can answer that.
Objection withdrawn.
no,
And again, we're talking a lot about the video. The video, most of it is what takes place immediately prior to when you shove him. Is that correct?
Yeah,
Immediately prior to you shoving him, did he threaten you?
I couldn't hear you.
no,
Yeah, sorry, what was
I
that?
couldn't hear her response.
no, he didn't threaten me on the way out the door.
Did he raise his hand or do anything to try and make you think he's about to attack you?
No, not in the video.
And the video is what happened immediately prior to you shoving. No further questions.
Redirect.
Just one, Judge. Did you want him to slam your head into the wall 2 times?
No,
Okay, no further questions, Judge.
Just because there was a time frame and the question about immediately prior, your understanding of immediately prior is the clip in the video, is that what your understanding is? When asking, did you shove him immediately prior to exiting, or were you threatened, I should say, immediately prior to exiting? Are you, in your mind frame, is that time frame just the portion that's shown in the clip? Or are you including the time before the clip in that immediately?
I was just referring to the clip in the video.
Okay, I don't know if that was the prosecutor's intention when she questioned, so that was a concern I had. The prosecutor, can you clarify that question if that was not the time frame you were referencing?
Yeah, no, in hindsight, not a great question. My apologies. I guess I'll ask both. In the time frame of the video, were you threatened?
Yes,
In that those 17 seconds, he threatens you?
no, not in the video, no.
Okay. 30 seconds before you shove him. So now we're outside the video. 30 seconds. Did he threaten you?
When I was leaving,
30 seconds before you shove him.
no,
Let's go 2 minutes. Did he threaten you
before the video,
before you shoved him?
no. I mean, when we were upstairs, I felt threatened when he grabbed me by my ponytail and put my head into the wall. To me, that was threatening. He put his hands on me. He grabbed me by my hair. He put my head into the wall. So to me, yes, that was threatening.
When you're saying that he did that, you were able to get out of that situation, correct?
Yes,
And you were able to get out of that situation without assaulting or battering him at that moment, correct? And you did that by getting away from him.
yes,
In the video, he doesn't move towards you. He's not himself moving, but he doesn't move towards you. Could you have moved away from him?
things on where my kids are out front.
Just for the sake here, could you have moved 2 feet away from him?
Yes. Suppose I could have.
And would that have been a way, if you had felt threatened, for you to have put some space between you and him?
There was a little bit of space until I tried to leave.
Until you shoved him?
Yeah,
No further questions.
Does Joey have any questions? It's not good.
Pretty good.
It's not good. Means you all didn't ask enough questions.
I know. I tried.
I have never seen this before. Okay, if your Jeep was in the shop, how did you get in your car and leave that day?
my Jeep was parked at his shop. That is a Grand Cherokee Jeep. I drive a Ford Flex.
You have more than one car?
What, yes,
You have more than one vehicle. Okay, that answers that. In the moments leading up to you shoving him to exit the door, were you feeling threatened?
no, not at that moment.
Okay. Were you concerned for the safety of your children?
Yes, I got them out the door first.
On June 22nd, what time were you off work?
I got off work at 2:30,
And what time did you get home?
roughly maybe around 4:30ish.
Where do you know, that is, I would say, do you know where he was coming from, or how did it end up that he was in a position in front of you when you pushed him? Do you know where he was coming from?
It was coming from outside, but I couldn't tell you. I couldn't tell you. I don't know.
Were the roommates present during this incident?
Yes,
Okay, you believe they witnessed this incident?
yes.
Why is it that you never unpacked your bags from the incident prior?
Because I've had my stuff thrown on the porch, out on the porch more than twice.
What does that mean? Can you explain that to the jury? You had your stuff out on the porch more than twice? Why?
I've had my things thrown out on the front porch more than twice. So by the time it happened in April, I never bothered to unpack what was left because every time I threw my things in the porch, I just loaded them up in my car and took them to my mother.
Okay. And I'm not sure that this is the best question for this witness, but I'm gonna try to formulate it for this witness, because I know we talked about a lot of cameras, or at least you testified about a lot of cameras. Was there video, or was there a camera that would have picked up the incident in the hallway upstairs?
Yes,
Okay, so there would have been video footage of that?
should have been video footage of the incident upstairs as well as the outside on the porch.
Okay. The actual question here, I'm not gonna ask because it's not a question for this witness. As there was another question, this particular one, I asked two other questions. There were at least 4 questions on this sheet of paper. One is, I'm not gonna answer because it's not, this witness cannot testify as to why those roommates were not subpoenaed as witnesses. And this is not a civil suit, so she wouldn't make a counterclaim. Okay, and was Mr. Rutherford blocking the entrance or the door entrance in the video that was played?
Yes,
You mentioned, where you testified multiple times about the locks being changed. When he changed the locks, were your minor children living in the house with you?
yes.
Are you aware if the cameras are constantly or continuously running, or are they motion triggered?
No, they're constantly running.
Okay. Any more questions? Any redirect after those questions?
Yes, Judge. Okay, so there seems to be some confusion because you said he was coming from outside when that video clip happened.
Yeah.
But your testimony said that you were upstairs, he slammed you into the wall and you came downstairs. So how could he be outside coming in when that happened?
I couldn't tell you. I don't remember even coming down the stairs.
Do you know for sure that he was outside?
I mean, he looked like he came from outside. I mean, all I know is he was in the door entryway.
And when the video starts, you're coming around the corner, right? So you didn't just, or did you just go straight down the stairs and shove him?
No, I had come down the stairs and I don't remember coming down the stairs. I just, like I said, I don't know. I just know that I came down the stairs. I wouldn't have even known I grabbed my laptop. Had
Where
I
was
not seen it.
where was your laptop?
Sitting on the dining room table.
So could you have been coming around the corner from grabbing your laptop?
In the video?
Yeah,
Yes, I was coming around the corner from grabbing my laptop.
well, you just said that you didn't know, so which one is it?
What do you mean?
You said that you don't really remember what happened. Do you understand what I'm saying?
I only know I grabbed my laptop because I seen it in the video.
Okay. So is it possible that somewhere in the video that he hasn't provided intentionally, you came down because he was behind you, he's in the narrow hallway,
It is.
you came down, got your laptop, and he went past you to block the doorway?
Possible, yes.
Okay, so big discrepancy here, because you say you got off work at, I don't remember what time, 2:30?
2:30.
You got home at 4:30? The time on the video is 9 o'clock. You know what I mean? How do you explain that?
I cannot. I just know that I just gotten home. It happened shortly after I got home.
Okay. They asked about when he changed the locks, did you always, were your kids living there?
Yes, they were.
Okay, did you always take them with you before he changed the locks?
Yes.
Okay, so you got your kids to safety and you to safety, but then you always went there, right?
Yes.
No further questions, Judge.
Was there any recross?
Oh, no, Your Honor.
Any other questions from the jury? Okay. do you want to go? I'm happy that the questions are coming now, because what happens is they'll hold your questions and then you'll go to deliberate, then you'll have questions and it's too late to ask the witness. So if you have questions, ask now. Can you change the time on the cameras? Do you know that?
Yes, I mean, I can't say for sure. But, or maybe they were already set wrong prior to.
Okay, so
It's
that the time could
possible.
be set on the camera?
Yes, you have to set the time and dates, so they could have been off.
Any other questions from the jury? Okay, doesn't look like there's any. Can this witness be excused from the stand?
Yes, Your Honor.
I thank you, you may be excused from the stand. And the defense can call the next witness.
Judge, the defense rests.
Any rebuttal witnesses?
No, Your Honor.
Okay, well, I'm gonna give the jury a 10-minute break and then we'll do, well, maybe 20 minutes, because I need to go over closing instructions with you all. And then we'll come back for closing arguments and then final instructions, and then you'll be free to deliberate. But you're not free to deliberate yet, so you're not free to discuss this matter until you're ready to deliberate, okay? This is time to get some water, and we'll see if we can bring you some snacks. Now's the time for closing arguments. Trustee, are you gonna go first?
Yes, Your Honor. And I will require the, or I'll leave the screen sharing on the Zoom so that I can.
I can give that to you. Just a
Thank
moment.
you. I won't need it right away.
I'm gonna, I just make you co-host. Someone is in the living room. Why?
Pretty young. Mhm.
Just a moment, someone just logged into my Zoom room. I'm trying to get them to go into this. There they go. Okay, you're free to go.
Good morning again, everybody. Again, I'm so glad you're all able to brave your way in through the ice and snow, and I'm very grateful you're all able to come and be here this morning. Before we get started, I want to thank you for your time, for your engagement with this case, and for your diligence in hearing this case. I truly appreciate all of your note-taking and your question asking, because it shows me that you're taking this, your civic duty, just as seriously as I, in defense, the court, all are taking this case. And it's incredibly clear that you respect the court and the process. And I, in return, I have a lot of respect for you. And it's because of that respect that I have for you and for your time that I'm gonna try and keep this pretty quick. And I'm gonna cut straight to the point, which is potentially gonna be a little uncomfortable. Stephen Rutherford is not a perfect victim. I think that's pretty safe to say. And you know what? It's probably fairly likely he is not a perfect person. None of us are. But Stephen Rutherford is not on trial today. And he was not on trial yesterday, even when he was testifying. That's because she's very prepared. She is going to likely have a laundry of all of the different details in evidence that have come out through this trial that paint Mr. Rutherford in a pretty negative light. And that's her job. That's what she's here to do. But when you listen to her and when you go back into your deliberations, I want you to remember what I am required to prove, but also what I am not required to prove. Okay. First, I'm required, this is pretty simple, required to prove the date of the crime and that the crime took place in Lansing, Ingham County, state of Michigan. The testimony here is pretty simple. No one, not even the defendant herself, is disputing that this took place, that the assault took place on June 22nd, 2023, at 1119 North Walnut Street, which is in Lansing, Ingham County, state of Michigan. That's not really in any sort of dispute. The next thing that I'm required to prove is that the defendant, Danana May, and Stephen Rutherford had some sort of domestic relationship. Again, this is pretty easy. No one's really disputing that they were in a romantic relationship for about a year to a year and a half, give or take, that they were engaged at the time and that they had been living together. I don't have any concerns about you guys believing me on this. But next, I have to prove that an assault or an assault and battery took place. And I won't belabor the point because you've heard the definition multiple times and you guys have a really good grasp on it, which is fantastic. And you're going to hear it again from the judge. But just real quick, a battery is a forceful, violent, or offensive touching of someone else or something closely connected to them that is done intentionally. That is, the person committing the battery intends to do the action. What their intent is, they're intending to do the action. And that the victim in the instance did not want that battery to take place. An assault is just making someone fear that battery just described. And finally, I also have to prove to you that the battery that took place was not done in self-defense. I have to prove that to the same standard that I have to prove the other elements of the crime. And the way, so I have to prove that beyond a reasonable doubt. The way that I can prove that this isn't in self-defense, I can do that by disproving any or all, if possible, but not required, of the 4 different elements of self-defense. We're going to go through them in the jury instruction to the judge later, but I'm just going to give you a quick rundown so you can have this fresh in your mind, okay? So, Mr. Rutherford testified about 2 incidents on June 22nd, where Danana May touched him in a way that was forceful, violent, or offensive, that she touched him intentionally, and he did not want her to do so. First was when he spoke about being punched in the head or face area, and then the second was the show. I want to focus on the show, because you, as a jury, got a pretty, about as good of a view of an assault or a battery that any jury gets. You watched it happen on video. And I know it is a short video. I, like you guys, I'm curious, I'm nosy. I always wish I had more. However, this is what we have, so this is what you are going to be able to view and what you are going to be able to draw your conclusions from. This short video, it's pretty clear. The majority of the video, the majority of the time, is actually the most important part for your analysis of whether or not a battery took place. Because most of the video takes place before Danana May shoves Stephen Rutherford. That moment before is so important because that is the moment that you as jurors need to be looking at to determine whether the defendant actually acted in self-defense. I'm going to play the video for you one more time before you go into deliberation today. But before I do, I'm going to walk you through elements of self-defense. Remember, I only have to disprove that she is acting in self-defense. I only have to disprove one of these 4 elements. And then if I do that, it is not a complete defense of self-defense, and therefore she cannot claim self-defense, okay? Oh, excuse me. And you know what? I see you guys got your notebooks. I love that. You can keep track of these elements, and then when we're watching that video, you can take notes. Did this happen? And I want you to keep track. Were these elements for self-defense, were they met? Or did the things that you see with your own eyes in the video immediately preceding the battery, did it take place? Right? So the first element of self-defense is that when the defendant acted, in this case, shoved Stephen Rutherford, she must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force against her. Just generally having negative feelings about someone, that's not enough to honestly and reasonably believe that the unlawful physical harm is imminently happening. There needs to be some sort of threat. There needs to be something besides just, I have got history with this person. That's not enough. Besides what we see in the video, from the questions that you asked the defendant today, one of you, and I don't know who, none of us do, asked, and I apologize if I get the wording a little bit wrong, but essentially asked, did you feel threatened right before you shoved him? And Danana May, the defendant, she answered no. That is the number one thing. How can you be acting in self-defense if you are not feeling threatened about some sort of unlawful physical attack toward you? She said she didn't feel threatened. So I want you to take her words. If you're going, you as a jury get to choose who you find credible when they're telling the truth and when they're not. That's your job and that's your duty. But on the stand today, she told you, I did not feel threatened. The next element of self-defense is that the defendant could only use the degree of force necessary to protect herself from the danger. So she can only use an appropriate amount of force given the circumstances as she saw them. Now, obviously, if she didn't feel threatened, as she stated, and as we'll see in the video that you've already seen, he did not make any sort of physical motion towards her. He did not try to attack her. He did not touch her. He didn't even raise his voice at her like she alleged he did in prior arguments. None of that happened. He was talking to her. She was the one who was acting upset and loud. Those are things that you can consider, okay? So what is the appropriate amount of force when you're not threatened? There is none. Something that I want you to keep in mind when we're watching this video. It also is a part of that element. When you're considering what type of force or amount of force is necessary, you should consider whether she knew about any other ways to protect herself. Could she have stepped further back? Could she have gone back upstairs? Could she have waited until the defendant got the key that he needed and he left? Was the only option that she had for her to shove him through the doorway and at least into something? I know there have been multiple different testimony about whether there was the code red or not. He fell into something, right? So I just want you to keep that in mind. Was there any other option that she had? Or was the option to take a conversation being had at voice level to elevate it to the level of a battle? Okay. Third element of self-defense, the right to defend oneself only lasts as long as it's necessary for protection. Again, she didn't feel threatened and he did not attack her. So I think it would stand to reason that the amount of time that it would take for her to be exhibiting, or I guess exerting force and acting in a way in self-defense, she didn't need to be necessary herself. She said she wasn't threatened. So again, I want you to keep that in mind. And fourth, the person claiming self-defense, here the defendant, must have not acted wrongfully and brought up the assault. Arguably from the video, that fourth element admittedly is not addressed as much, but I don't have to disprove all four. I have to disprove at least one. So I want you to keep these in mind as we watch the video. And again, it's a short video, but it's important. And so sorry, technology is not. My volume's not working. My apologies.
Gonna try this way.
Oh, that was the wrong thing to do. Sorry again.
Did you click share sound when you click share?
Now I'm not so sure.
It's okay. I think I'm going to have you start it over.
Okay. Sorry, guys. Here we go. Okay. My mistake. I did not click there.
Not for you. What's that? Change your fucking locks. You good at that. Fuck out my way. You can fuck out my goddamn way, motherfucker. Fuck you.
Okay. You guys, it's a little casual, ladies and gentlemen. You will have access to all of the exhibits if you'd like when you're in deliberations. If you need to watch that video again, you are more than welcome to. Okay, just make sure you talk to the court. You're all very smart jurors. We pretty much lucked out. We had to really get into the nitty gritty very little. And during our discussion during voir dire, I know that you understand the law. Now, today I'm asking you to follow the law that you have learned. When you get down to the evidence, when you get down to what you can watch, see happen, It is clear to the standard beyond a reasonable doubt that when the defendant shoved Mr. Rutherford, she was not being assaulted by him. She was not being threatened by him. She stated herself to you that she did not feel threatened in response to the question you asked her, right? Mr. Rutherford, it's a little hard to tell, but from his testimony, and I've watched this video a few times, he's asking it for his keep. That in and of itself, that's not a threat. A person could not reasonably and honestly interpret asking for a keep. He doesn't move at her. He doesn't even raise his voice at her. But still, she intended to and succeeded in forcefully, violently, or offensively touching him when he did not want to be touched, and she shoved him. Even if you could watch that video and come to the conclusion that she did think she was in imminent danger, the amount of force that she used was not appropriate given the circumstances. She could have, again, we've talked about this a little bit, she could have backed up. She could have gone elsewhere in the house. She did not have as her only option to shove her entire self up against Mr. Rutherford, causing him to fall back and smash his head. I'm asking you, the jury, all of you all agreed under oath during voir dire to hold me to the standard of proving my case beyond a reasonable doubt and not to a higher standard. I want you to keep that in mind when you think about this evidence, but I especially want you to keep that in mind when you think about the evidence that you are able to see with your own eyes. That video shows you that Danana May committed a battery against Mr. Rutherford and that she was not acting in self-defense. Additionally, Danana May's testimony establishes, she says, I shoved him. I wanted to get through the door. We hear her yelling. We hear her swearing. I'm not here to prove or disprove that she was angry at him for a good reason or a bad reason. That's not my job, and that's not part of my proofs that I have to provide. Whatever reason that she's angry with him, she was angry. And the way that she dealt with that anger was to shove her way out the door in a way that was not in self-defense. You all agreed that if I proved my elements beyond a reasonable doubt, that you would return a verdict of guilty. I'm asking you to follow your word. I'm asking you to examine the evidence. And if you find that I have indeed proven my elements beyond a reasonable doubt, then I'm asking you to return a verdict of guilty for the crime of domestic assault against the defendant, Danana May. Thank you all so much for your time. I know this has been quite a process.
Mr. Rowe.
Thanks, Judge. All right, you guys. I love parent music. This is not parent music. There is no smoking gun. There is no witness on the stand that's going to testify that they actually did it. We've got broken people testifying to something that happened. And everybody wants to be viewed in a positive light. It's just the nature of people. So a couple of things that I just want to address briefly from Ms. Petrowski. I find it interesting that she wants you to disregard the punch. All she wants you to focus on is the 17-second video. 17 seconds. And we'll get to why it's 17 seconds in a little bit. But she talks about how Danana said she was not fearful the instant before she shoved him. And then the judge asked your question, or asked the question and said, did you feel threatened? She testified that she did. So putting myself in her shoes, when someone grabs me by my hair and breaks me into the wall twice, leaving a golf ball sized bump on my head and has me losing a couple days, all I'm thinking about is getting outside to my children. And what's standing between me and my children? This man. And I think Ms. Petrosky, it sounds like the argument is she should have waited. She should have backed up. She should have gone somewhere else. How long? He has a 15-year-old and a 10-year-old out in the car that's running. So the argument is that she should have protected herself when he was bashing her head against the wall. That's the only time that she can use force. Is if he is coming at her. What to make her think that he wasn't going to do it again? She said she was scared. She said she was scared because of the multiple times we went through one by one that he has come at her in the past. She's had to bring friends, have friends bring makeup to work to cover the bruises. There's not a picture of it. So she's supposed to wait until she's in the middle of that to get out. Doesn't make sense to me. So we talked about the presumption of innocence. You have to assume when you start your deliberations that she is innocent and take the evidence that you found and see if the prosecutor has met the burden. What it means to be presumed innocent, it's not being neutral, but it's one way you can put this into practice is if somebody brings up a fact that is unfavorable to Duana, and then somebody else brings up a fact, a conflicting fact that is positive for her, then you can remind them of the presumption of innocence. It always requires you to take the one that favors Duana. Hope that makes sense. If that happens, just remind them, well, it could be this. Somebody says, well, what about this? It could be this. There were a lot of different stories that came out over the last day and a half. Next is the burden of proof. So we've all talked a little bit about the burden of proof, and we talked very specifically about how we start off at reasonable suspicion, like a 35%, and it only gets higher and higher and higher and higher. And the burden we're talking about today is beyond the one is required to take away your children, to take your kids out of your care. This is a higher burden. So it's not just, yeah, I really think that that's what happened. Still not enough. And then reasonable doubt. You'll hear the judge talk about reasonable doubt. Beyond a reasonable doubt is higher than all of that stuff. And so I'm a visual person. We've talked about this. I have a visual aid for you guys. Great. So this is for purposes of determining the burden of proof. You're probably missing the bottom part soon. Okay. So I'm going to try to hold it up so you guys can see it. All right. So if someone who was proven to be not guilty, then it's obvious they're not guilty, right? However, we go through each of these levels. Highly unlikely. Okay, still not guilty. All of these greens, all of the shades, like we're talking about a paint store here, all of these are not guilty. If you go through each of these and say, well, is it, even if it's perhaps suspected, possibly guilty, we get to probably guilty. If you believe everything that she said and you think that Duana is probably guilty, still not there. Still not there. It's likely. You have a strong belief. All of this, you are still not there. So let's look at the elements of the case. Let's see if I can get this. All right. So that's not a good idea for judge purposes. Oh, everybody can see? Okay, so let's look at the elements. You've got a forceful, violent, or offensive touching. And so you heard her talk about force or violence, but if you look at the instructions say that the force or violence has to be, and I quote, so as to harm or embarrass him. That's one of the instructions. That wasn't mentioned, but it's in there. This action was not to harm or embarrass him. You heard her testimony. She was trying to get to her children. She wasn't trying to hurt him. There's a little confusion as to whether he could have even fallen into the coat rack. You saw the video a few times now. It's 17 seconds of video because that's all he did. Why is there not? Where is the video? Well, I'm sorry. I know why there's not more. Because it would show him ramming her head into the wall twice. It would show her coming down the stairs. Actually, the video from outside, he testified that there was a camera that is facing the door going outside. Where's that video? That would show her leaving, pushing her way out of the house. And we don't have anything beyond that 17 seconds. Because, you know, they said words even after she left. None of it. Why? Because it's going to make him look real worse than he already does. He has 14 cameras in and around the house. Not one or two. He testified to 6 or 8. 14. 10 to 14 is what she said. He testified there are cameras facing the entryway, but again, we don't have them. And then it's so hard to keep everything straight from his testimony because yesterday, for the first time, you hear him say, I got a notification that the cameras were out, so I had to come back home. He starts saying, well, I came in, you know, I went into work, I was on my way, and then the cameras were out. You listened to the whole body cam. You didn't hear anything about that. You want to know why? Because I wanted more of the video. He didn't want to give it up. That's his way of making it so he didn't have anymore. And they're battery operated, folks. He's claiming Danana disconnected them. How? How did she? And they're all separate. So how did she disconnect the batteries from 10 to 14 cameras? Or if you believe him, 6 to 8. Again, guys, it just doesn't make any sense. It doesn't. And we all saw the video. She is on camera saying, get out of my way. She's not saying, I hate you. She didn't grab a knife. She didn't get a baseball bat. Get out of my way. What's read between the lines is my kids are outside. I'm afraid you're going to do the same shit, the same stuff you always do. And so let's just say you find that she did. The prosecutor did meet her burden of proof for the elements of an assault, domestic assault. She still has to disprove self-defense beyond a reasonable doubt. So again, she honestly believed that she had used force to protect herself from imminent unlawful use of force. Again, you've got a situation where she has just had her head, and my head still hurts from getting slammed into that, whatever it is. Like she had her head slammed into the wall twice. And we are to expect her to stand in front of him until he moves out of her way. That's what we're going with. She used force to get outside and get to her kids. Justified in using the degree of force that seems necessary. Again, she didn't grab a knife, she didn't grab a baseball bat. She shoved him out of her way. You hear her, get out of my way. She used some choice words. She's not perfect, but it was get out of my way. And even his testimony that he was trying to get to the door, through the door with her. If he's so afraid and he gets shoved into the coat rack, Why is he trying to go through the door? He wants her to leave. He wants his key back, according to what she says, what Paige says. But he wants to get through the door with her. And then she has the right to defend herself only as long as it seems necessary for the purpose of protection. She didn't wail on him. All she did was shove him to get outside. She didn't, again, we may talk a little bit more about the punch, but I think we've all decided that it's very difficult for me to believe what he says about the punch. And it's very convenient that he has 17 seconds of video. These 17 seconds. Lastly, they must not, person claiming self-defense must not have acted wrongfully and brought about the assault. If you believe her, she had her head slammed in the wall. She's not blaming on himself. She's being assaulted herself. Then she was trying to get out of this situation. It's a continuous situation. Imminent use or imminent force, harmful force, destructive force, enough to potentially give her a concussion was used in the hallway. But the argument is, well, she had to protect herself that moment. Not, she's still in fear because she just had her head slammed into the wall twice. So she wants to get the heck out of it. It's not a case of domestic violence. You have a guy that says in opening, he loved her, he trusted her. Yet he's sending him text messages saying, "Where the fuck are you?" That on this night, "Where the fuck are you? Why didn't you answer your phone? Stupid bitch." Guys, this burden is so high. So high. She has to hit this on both of them. So, reasonable doubts. Okay. Some of the reasonable doubts go to the actual elements, but some of them are just doubts in general. And some of the actual doubts go to every element because they speak to the credibility of the evidence. And I spent a lot of time last night trying to sort everything out. I'll do the best that I can. I have just a laundry list of them. Let's start with the most obvious. His story changes so many times. I don't know if you guys could keep it straight. I have notes here and there. So let's start with, and this is a minor one, but again, he tells the cop they're together, or he testifies yesterday they're together for a year, and then tells the cop they're together for a year and a half. It's just not something that you switch around. He doesn't know her date of birth. All right, so my husband forgets my birthday. He doesn't know how to spell her name. Come on, I've been in relationships for 6 months, and they don't know how to spell my name. He says to you yesterday, we talked about this a couple minutes ago, he was driving into work when he got this notification the cameras were off. So he had to turn around and go back home. We didn't hear anything about that. The first story he told, which again, I don't think it's true either, but is that he was on his way. He's getting ready to go to work when he got into this altercation with Danana. So where did this story about the disconnecting of the cameras come from? Well, it comes from the fact that he doesn't want to give up video. That's where it comes from. And then he says, when he first, in the beginning of the video, I don't know if you guys remember, but he said, the officer said, "Oh, so did you call somebody last night?" And he said, "No, I had to go to work." So first he has to go to work. Then he was on his way into work and came back. And then later on, you hear him say that he was so physically and mentally shaken that he had to call off. So he called his boss, and his boss was like, "All right, I'll see you now." 3 different stories for one piece of this. One piece. Then you've got where he says he's hit. So first he says, "She hit me dead in the face." Dead in the face. That's what he did. Then later on, she wants to clarify. The officer wants to clarify. So where did she hit you? Well, she hit me like on the side of the head. That's a big fix. If it covers this, we're talking that's a big fix, or multiple hits. That's not what happened. Then let's talk about the dried blood. Yesterday, he came in and sat there and said, this dried blood was from the punch. Heard him on the body worn camera saying, there's dried blood there? Where did that come from? And she says, well, could it have been from the punch? Oh yeah, it could have been from that. But then he talks about cutting himself at work and being bleeding and not even know about it. Which one is it? He wants to appear this picture perfect guy and paint her to be this conniving devil. But you can't believe a word he says. So all of his changing testimony is just one reasonable doubt that goes to both of those. Not only self-defense, but also the burden of proof in the original case. Secondly, this was not a matter of priority for Mr. Rutherford. We don't know if he went to work because he's told 3 different stories, but he went to work, he went to T-Mobile. Well, again, we don't know because first he said he didn't have to go to T-Mobile. And then in the dash cam, he said that he did. He goes to T-Mobile and disconnects the phones. And then he changes the locks. So only after 3 p.m. the next day does he report it. And why? 1316 in the body cam. She needs to learn her lesson. And then he tells the cop, oh, well, her defense is going to be, he hit me. Now, it's easy to tell somebody what defense is going to be when you already know it because you don't. And you got the police officer. She didn't do an investigation. She did. She shows up. She interviews one person. She says 12 and a half minutes into the interview, I'm going to go find her and arrest her. I have 24 hours to find and arrest her. And 13 and a half, she's saying, I'm going to send charges up. If I can't find her, I'll send charges up. You heard her say that there were 2 roommates. Well, you heard someone say that there were 2 roommates at the house, two kids at the house. She doesn't interview a single one. She gets a phone number for Joanna, doesn't call, sends another county out to see if she's home. She literally put 20 minutes into this case. And you saw every single one of them. And then in her report, she says, and mind you, we talked about this. This is what the prosecutor uses to determine why to or whether to issue charges. She says Stephen advised that this type of assault was not new for him, but he's reached the point where he believes Duana needs to be held accountable for constantly assaulting him. When Stephen said 2 to 3 times this has happened tops, 2 to 3 times. I wonder if she got that from him saying she needs to learn a lesson. Then the cop says there have been several instances where Duana has assaulted him in the past. Several instances. You hear him say, Stephen, I was arrested for domestic violence. She didn't have any evidence, but I went to jail. That's nowhere in the report.
Objection, that's not an evidence.
What was the objection as to what portion?
He never stated that he had a conviction for any domestic violence, nor did he ever make any statement about receiving some sort of sentence for a conviction.
I didn't mention a conviction.
So that he said that he went to jail.
He was arrested and went to jail.
That's not facts, that's an evidence. How do we know
It was
that?
he testified as to him being charged for domestic violence in the past, and it was on the body worn camera footage. He said the whole thing, and I can certainly point it out to the court.
Counsel approach. Okay, so as to the objection, it's sustained in part and overruled in part. We'll have counsel restate it in conformity with the statements brought in through the officer.
Yeah, sure. You heard the officer testify that she knew he had been charged with domestic violence before. That wasn't in her report. So many things about his story changed. And we talked about in voir dire, how many times should you let someone lie to you before you don't believe what they said? Some more than others. And some, it matters what it's about, how important it is, how long it lasts. And I get that. What I will say is that the judge will tell you about jury instruction 3.6, which talks about bias and interest. You can decide that a witness deliberately lied about something that's important to how you decide the case. And if you decide that they lied about that, you can disregard all their testimony. Or you can believe part and disregard other parts. Every last word. You'll also hear about some jury instructions with regard to self-defense. And again, Ms. Petrosky talks about some of them. It says that evidence, I'm sorry, this is actually a jury instruction that talks about past violence by the complaining witness. And 7.23 says that there has been evidence that Stephen committed violent acts against Joanna in the past. Okay. You can consider this when you decide whether she honestly and reasonably feared for her safety. And that's in a self-defense context. What I want you guys to remember, so we've got about the, we've got as far as reasonable doubts go. Oh, criminal jury instruction 5.12. Someone asked a question about witnesses not being present. You know those two roommates? Where are they at? Not here. You heard us say they're going to be called as witnesses, and they are the prosecution's responsibility. They're not here. I would love to hear what they would say. What I will tell you is that 5.12 says there are witnesses that should have been here and were the responsibility of the prosecutor to produce them, but they didn't. And because of that, you may infer that this witness's testimony would have been unfavorable to the prosecution's case. One of them was sitting from me to that wall, that half wall. They are not here. We don't have the video. We don't have the benefit of having access, because this would be a completely different situation if we did. So let's talk about reasonable doubts. I try to sum them up, not as eloquently as I would like. Missing witnesses. Missing witnesses. We've got missing video footage. And my proposition is it's intentionally missing. We testified to 6 to 8 cameras. We have a 17-second clip. Changing stories. Number 3, changed his story several times. And even the prosecutor wants you to disregard the punch. Number 4, an absolute abysmal investigation. I hesitate to even call that true, because there was nothing. Conflicting testimony. So you had the mom and the friend testify as to how the relationship went. They testified as to prior violence, the times they've had to bring makeup to work. They've had to go get her, bring her and change the clothes because of the past violence. You got testimony that doesn't make sense. His testimony does not make sense. Why would she walk in and punch her? I'm leaving. I'm going to punch you. Doesn't make sense. He was standing in her way. The biggest one, in my humble opinion, I want her to learn her lesson. She learned it. She told you she learned it. There is no intent to harm in this case, as is required. And even if you find that she did intend to harm, she was pushing him so she could get outside to her 15-year-old and 10-year-old. I asked her to come back.
Any re-argument?
Just briefly. So I have 2 points that I just kind of want to clear up, make sure that you have the right information going into your deliberations. First, I just want to remind you that body cam footage, that is not an exhibit that is entered into evidence. So anything that is in that body cam footage, you can use to determine whether or not you find Mr. Rutherford credible. That's fine. But you cannot use whatever is in that video to determine whether or not the assault occurred. Okay? That evidence, or not evidence, that video is only to be used in determining whether or not he is credible. And next, I just want to briefly talk about what imminent means. Imminent is something that is about to happen. It's not something that could happen. It's not, oh, I don't feel like amazing about this, or maybe I've got some history. It's you, if you do not change what is about to happen, you are going to suffer an assault or bad. That is what imminent means. For instance, I mean, we have defense has talked a lot about, like, because Juana has stated that she has, or has alleged that she suffered these assaults. Mr. Rutherford. I'm gonna just pull a pretty dated pop culture reference out here. Who else? You guys heard of Chris Brown? He's a musician, dancer, kind of famous for committing domestic assault against Rihanna. If you have that knowledge that he is someone who can be violent, who can commit acts of violence against someone else, you have that knowledge about him. If you saw him standing in a doorway, if you thought, ooh, he has the ability to commit an assault, does that make you justified in that moment to shove him? Does that give you the right because you have this knowledge about how he may have acted in other times? No, he would have to do something in addition to that, because otherwise you are the person who is committing that. It's not enough to just know things about a person. There has to be the situation in and of itself has to make you think that harm is coming to you imminently. That's all I want to do. Thank you guys.
Okay, that concludes closing arguments. If you can turn your attention to the screen, I have some final instructions before you're free to do your duty to deliberate. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is an honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits that were admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge that you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide the facts, what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How long did the witness look and act while how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how you decide this case? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you consider or you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about June 22nd, 2023 in the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, including me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and a full copy of the instructions. If you want to look at any of the reference materials or documents or exhibits that have been admitted, you just ask. I'm going to send the exhibits back with you. The only one I won't be able to send is going to be the flash drive. I'm going to have to bring you back in here if you need to see the video again. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, today's case may be snow, that is direct evidence that it is raining. Facts can be proven also by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a coat covered with raindrops or drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You have heard evidence that before the trial, a witness made a statement, statements that may be inconsistent with his testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how you believe or how believable the witness testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement or statements when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. When you decide, then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness who is a police officer. The testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Michael Delamarter and Zachary Thornburg are missing witnesses whose appearance was the responsibility of the prosecution. You may infer that this witness or these witnesses' testimony would have been unfavorable to the prosecution's case. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. The defendant claims that she acted in lawful self-defense. A person has the right to use force to defend, in this case herself, under certain circumstances. If a person acts in lawful self-defense, her actions are justified and she is not guilty of domestic violence. You should consider all evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself. But you may also consider how the excitement of the moment affected the choice that the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. There has been evidence that the complainant, Stephen Rutherford, may have committed violent acts in the past and that the defendant knew about these acts. You may consider this evidence when you decide whether the defendant honestly and reasonably feared for her safety. There has been evidence that the complainant, Mr. Rutherford, may have had a reputation for cruelty or violence. You may consider this evidence when you decide whether it was likely that the complainant threatened to hurt the defendant physically and whether the defendant honestly and reasonably feared for her safety. Again, the elements of the crime of domestic assault. The defendant is charged with domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Stephen Rutherford. A battery is a forceful, violent, or offensive touching of another or something closely connected to him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Mr. Rutherford's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Mr. Rutherford reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery or must have appeared to have the ability or must have thought she had the ability. Second, that at the time, Mr. Rutherford was one or more of the following: that he was the defendant's spouse, former spouse, that they had a child in common, or was a resident or former resident of the same household as the defendant. Also, you can consider whether or not the defendant and Mr. Rutherford was a person that defendant. Also, you can consider whether Mr. Rutherford was a person with whom the defendant had a previous or dating relationship. A dating relationship means frequent intimate association, primarily categorized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. As used in these instructions, the word force and violence mean any use of physical force against another person as to harm or embarrass him or her. For a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against Stephen Rutherford's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. That concludes my instructions. You will get a copy of the full instructions for your reference. Again, you must first choose a foreperson. And if you have questions, you would have that foreperson write those questions down. And they will be provided to the court officer who will be seated right outside your door. Don't let anybody outside that court or that jury room know how you're ruling at that time. If you want to see the exhibits that were played on the screen, you would also send a note and we'll get you back in here to see that. The other exhibits will accompany you back with the jury instructions. Let me swear.
Yes.
Wouldn't know it from.
Well, I just didn't know.
Okay, you can be seated. All right, my understanding is that you have a verdict. Who's the foreperson?
I am, Your Honor.
Okay, and that's correct. You do have
You
a
do have a
verdict? Okay, can you stand and read the verdict?
Yes. Just the verdict, just,
You should read the entire form.
all right. Defendant Danana May, count 1, domestic violence, possible verdicts. You may return only one verdict in each count, mark only one verdict for each count, and we return not guilty.
Do you want the jury polled?
No, Your Honor.
No, Your Honor.
Thank you. And thank you for bearing with us you've been here for a full day at this point, but 2 days consecutively, and you've been attentive. You have asked wonderful questions. This is historical for me. I've never had all these questions from a jury, but that means that you're paying attention, your wheels are turning, and you're asking questions so that you can do your job more efficiently when you go to deliberate. And so we appreciate your willingness to serve and to be here today and to render a verdict so that justice can be presented here in court. So thank you again. I'm going to release you. I think you do need to go back downstairs to Treasury again, and then you'll be free to go. If you wanted to stay behind and have conversations with either of their attorneys, that's completely up to you, but they are available for that purpose if you'd like, okay? You may be excused. I'll take that, sir. Thank you. Be seated. We have a not guilty by way of acquittal. We'll get you that paperwork in just a moment, and congratulations to you, ma'am. Okay.
I'm trying to know if they're willing to stick around and chat.
They usually just stick around. So
Can we go?
you're free to do that right now. I'll get you the paperwork.